Today we're in Judge Sam Meyer's courtroom in Thurston County, Washington, where we have a defendant who got into a domestic argument with her husband over a bottle of shampoo. Both the police report and the defendant say he hit her first, yet they charged her with assault. The husband appears in person with an impassioned plea to persuade Judge Meyer to let her go back home. Does it work? Roll footage, law nerds.
At the Thurston County Correctional Facility, Mr. Parker, who's seated to your left up there?
Good afternoon, Your Honor. This is number 40 on the calendar, Mrs. Susan Smith. I've advised Mrs. Smith of her constitutional rights, and I believe she understands them. Based on her lack of income, she qualifies for Thurston County Public Defense to be appointed as counsel. We are contesting probable cause on this based on the deputy's report, in that the alleged victim admits in the report that he struck her first. Yeah, so we object to probable cause, Your
Honor. Give me just a moment to review the police report. Mr. Fortunato.
Your Honor, I would just remind the court and counsel that the determination of primary or initial aggressor is not a determination for a probable cause hearing. State is more than satisfied, based on the probable cause declaration that we provided, that there is probable cause for assault in the fourth degree here. That is all. I reviewed the police report. Seems to be almost a mutual combat type of situation. With regard to probable cause, which is a fairly low standard, I will find probable cause for assault in the fourth degree domestic violence. So the case will go forward. Mr. Parker, did you discuss with her legal rights?
I did, Your Honor, and I'd like to make a correction on counsel. Mrs. Smith has retained private counsel. We are represented for the purpose of this hearing only.
All right. So then, Ms. Smith, we're going to set conditions of release. I'm going to hear from the state, and then I'll hear from Mr. Parker. And then who was hired? Just, or you're going to look for one?
Oh, we just have a first name, Your Honor. We're not sure of the last name.
Okay. Well, the only reason I say that is just to make sure that whoever you hire, make sure they get a notice of appearance into the court as soon as possible. Well, that's all. That's the only reason I'm asking. And Mr. Fortunato, what's the state's position on release conditions?
Your Honor, there's no objection to a PR release. Mr. or Ms. Smith has no criminal history. I do think it's appropriate. I am going to be asking for our standard domestic violence conditions, including no criminal law violations, no firearms or deadly weapons. And Your Honor, I am going to be asking for a no contact order to be imposed. I understand Mr. Smith is here in person. I've had the chance to speak with him. I believe he has a difference of opinion on whether or not a no contact order is necessary in this case. However, I am going to be asking for one. I will highlight, based on the probable cause declaration that you previously read, that there does appear to be some substantial concerns about the aggression here. And I do think it's appropriate, at least at this time. I would, of course, ask the court to hear from Mr. Smith as well before making that determination.
You can come up. You're Mr. Smith?
Yes, sir.
You can take a seat at that table there.
Yes,
So what I'll have you, I don't want you to talk about what's alleged to have happened, just on the position of a no contact order.
well, we have a 32-year-old daughter that has very bad arthritis, and so she lives with us. My wife takes care of her. I love my wife very much, of course, and we've never had a problem. We don't drink. We don't do drugs. We just have enough money to get by. We're going to have bills coming up. I have no idea how to use a computer very well. And her and the daughter got into it at the, we have a couple of horses, and she was riding. She just walks. And I asked her if it's okay if I went to the show, and she said, yeah.
But again, I'm just
Right, you're not into that.
not in that, well, no, I am, but I mean, now's just not the appropriate time to,
Right, yes, sir.
try
right.
the facts of the case. It's just going forward here.
Yes,
And so I didn't realize you were in the courtroom, but it looked to me like things were kind of going both ways there for a bit, which
It
is kind of
was.
concerning. And so again, I don't want you to,
no, sir.
again, I'm just
No,
giving my impressions, and now's not the time for you to be testifying about that, but
No,
yeah, go ahead.
thank you, Your Honor. I was just pray that you show some grace and let her come back. And there's so much, and I can't keep up with it. I can't do it. And it's gonna tear my daughter apart. Other than that, we've never had a problem, sir, Your Honor. Never. And I'm not gonna say no more about that. And she was just tired. And
All right.
yeah.
Well, let me hear, Mr. Parker, anything you'd like to say at this time?
Yes, sir. I'd just like to echo the fact that they've been married for nearly 30 years and have never had an incident. There's no criminal history, no indication of any injuries that required further treatment or any treatment at all between the two of them. It was an alleged misunderstanding that perhaps got out of hand, but neither one of them is able to maintain the care for their daughter or the care for their home and bring an income by themselves. And to remove Mrs. Smith from the home would create not only a financial burden upon Mr. and Mrs. Smith, but a medical burden upon their daughter. And so we don't think a no contact order would be justified in this situation.
Mr. Fortunato, anything further?
No, Your Honor.
So ma'am, you're going to be released on your personal recognizance. Conditions of your continued release are you're not to have any criminal law violations, don't possess a firearm or other deadly weapon. I'm going to set a court date for 2 weeks from today on February 12th. 8:30, okay, it doesn't matter. At 8:30 for arraignment. There's no criminal history of any sort. I've heard from you. I've heard from Mr. Smith. So at this time, based on what I've heard, I'm not going to enter a no contact order. So hang on just a second.
Yes.
So, but that can change real fast. So I'm not sure what happened. This looked to see like a fairly innocuous thing over shampoo in the bathroom. And the next thing you know, there you are. So something like that can't happen again. Something like that happens again, there will be a no contact order. You won't be able to go home. Then we may be talking about bail. You'll be held up there in custody for a while. Do you understand that?
I do, sir.
I'm not talking to you because you're not the one who's going to go to
I'm
jail if
sorry.
that's happened. I'm talking to you, Ms. Smith.
Excuse me.
Yes.
Next court date will be February 12th at 8:30. She'll be released here later today.
Thank you, Your Honor.
It sounds like Judge Meyer made the right call. Let's hope we don't see the misses in a future Law Nerds video. There are many states in the U.S. where the judge is required by law to issue a no-contact order in cases like this, so it seems to be a good thing for the parties here that Washington is not one. Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me, and let me know what you'd like to see and how I can improve. Thanks.